The four of us up here do a lot of work representing nursing home residents and their families. So we're going to talk a little bit about that subject and a little bit about the lessons we learn from nursing home work that's applicable to all kinds of personal injury and wrongful death cases. When a client hires us, they're hiring us for two reasons. Number one, to hold the wrongdoers, hold the people that injured or killed or maimed them or their relative accountable. And the only way we can do that in our system is by a dollar amount. What is fair and reasonable for the harm that occurred to our clients? So one of the things we like to say is it's not about feelings. So when the negotiator or the mediator says, at the end of this process, I could all make you feel a little better, I say, that's not your job. The second rule that we try to follow is, when you go into these mediation, you need to recognize unequal bargaining power. Plaintiffs, and sometimes plaintiffs' attorneys, are risk adverse. Another principle of mediation is, at least how we do it, is past results do not predict the future. So if people say, well, all these cases settled for X amount of dollars 4 years ago, that in no way is predictive of what a jury will do on the case that's before the mediator. Each of our clients have a story. Each of our clients have suffered. Each of our clients have different considerations. So when they start telling you, well, this case settled this amount of time for this money, it's a meaningless number. Our next one is, and this may be one of the more important, maybe the single most important fact in governing settlements. People talk about the facts of the case, but in my opinion, what really drives the value, what the I'll say better, more successful lawyers achieve more money in settlements is because they're willing to try the case. So you have to evaluate your own case on what you think it's worth at the time you have it, at the time it's going to be tried. The case that Margaret won, both in the trial court on appeal, says that the defendant not only has to pay our costs, our fees, but have to pay our costs. So now we have no limits at all. Now we will maximize every recovery we can for our client because we have the money to fund the case. And as long as it's not coming out of our client's pockets, ultimately, that empowers us.
The case is called Grauer versus Claire Oaks. It's a 2019 appellate decision. The case was a trial court victory for the plaintiffs of $4.1 million. And Burlak basically said it needs to be reasonable and outlined some of the factors from a case called Madalinsky that cites to the rules of professional conduct in determining the appropriateness of attorney's fee. I will turn it over to Kelly and Steve, who are going to talk about some of the common defense tactics at mediation and how to combat them.
And one of the things we see a lot now is the apology tour. Put them in a position where they can walk. If they want to walk and they want to leave, and leave it on the table, that's fine. But we'll always be the last ones to stay. I'm not saying you're going to cave in or limit what you're going to do, but at least stay and let them walk. Sometimes when you get to these mediations, you get a lot of defense lawyers fishing around to get your theory. I don't think they always catch on to plaintiff's theories, especially in nursing home cases. I don't think they know where we're going. So you get a lot of fishing for facts. They want to talk about facts a little bit. They don't want to disclose too much, but they want the mediator to relay some facts to them. Lately, we've kind of been avoiding talking in detail about anything that's not apparently obvious. Otherwise, we just get into the numbers because sometimes they're just fishing and you get these low offers that are worthless and they only came to try to find out what you knew. I think preparing the client's the most important. We tell all our clients nothing is going to happen. If it's a 9 o'clock mediation, it ends at 1:30, nothing happens till 1 o'clock. So just read your phone or eat some crackers, whatever you're going to do. But if you prepare them for the wait, I think you'll give yourself a better opportunity to get the best result for your client.